I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what is going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are doing number 183 on our compilation list. I know all of you have seen Judge Brian Oakley in the thumbnail, and yes, he is a part of this compilation, but it is not for a sov sit, but a non-sov sit. And it's the reason why I'm telling you this is because I'm going to be sharing that particular clip at the end. And the reason why I added it as somewhat of a bonus for you guys is because it's definitely Judge Oakley in his element, no nonsense, not playing. And I know a lot of times you guys like to see him in that mode. So yes, Judge Oakley is a part of this compilation, but he will be the last judge that we will be featuring in this compilation. And before I tell you the other two, don't forget to like, comment, share, and subscribe. Chapters will be added for your convenience. If there's any commentary to be added to these from the previous showing of these proceedings, we will do so. Now, the first two judges before Judge Oakley. First, we will be in the courtroom of Judge Michael Olsaver out of the state of Michigan. And second, we will be in the courtroom of another popular judge, that is Judge Stephanie Boyd out of the state of Texas. And last but not least, one of your most favorite judges, courtroom we will be in will be Judge Brian Oakley. Listen, let me know down in the comments, guys, what you think about how Judge Oakley handled that situation. Was it fair or foul? Just let us know in the comments. And also with these other proceedings, whatever it is that you want to say down in the comments, you are welcome to do so. Now, it's time for me to get out of the way because what you really came to see are these proceedings. So let's jump in to 183.
Okay, we are on the record in file 21-20513-FH, People versus Robert Joseph Mattson. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. Mr. Mattson is present from the Lenawee County Jail. Mr. Mattson, my court notes indicated that at the last hearing, you waived your right to be represented by an attorney. I am required to advise you at all stages of the proceeding that you do have a right to be represented by an attorney. And if you can't afford an attorney, the court will appoint one for you at public expense. Do you understand that?
I don't think you'd be violating your oath of office, Your Honor, by allowing me to the right to a fighting clause.
Sir, I didn't ask you about any of that. I asked you if you understand.
I will, however,
Mr. Mattson, don't interrupt me. The question I asked you is whether you understand that you have the right to be represented by an attorney.
I do understand I have a right to be represented by an attorney or not. Yes, sir.
Okay. You've previously waived that right. As I said, I have to advise you that at every stage of the hearing. So I have to ask you again, would you like to be represented by an attorney at this point?
As I started to say, Your Honor, I don't want the representation. However, I will use the help of handling paperwork due to my means here and having access to certain things in paperwork. I will use your court-appointed attorneys just to help with some paperwork.
Okay, so you don't have a right to have the public defender's office do your paperwork or handle any of that. You have the right to have them represent you or not represent you. So that is your choice.
Not represent me, that's fine then.
All right. So you've previously been arraigned on the probation violation. Do you know how you want to proceed? So your options are you can plead to it if you want, which means you'd be admitting guilt. The other option is that I can set it for a hearing and we can have a hearing on the matter, and then I'll decide based on the evidence submitted at that hearing.
Your Honor, all due respect, I wish, are you working under oath of office today, sir?
Sir, I'm not going to answer these questions or deal with this. We've dealt with you before and your sovereign citizen arguments. I've rejected them all.
Citizen.
Sir, do not interrupt me. Do you want to have a hearing or do you want to plead?
I'll take your silence under your oath, Your Honor.
Okay. Do you want to have a hearing or do you want to plead?
I want the hearing. I want to go to trial. I want to go within the 90 days to a trial or sooner.
All right. So Sierra will need about a 1-hour hearing on a probation violation.
As well as I'd like you to have the arresting officers that arrested me on that day. I would like their sergeant to be dressed in uniform and at that trial on that day as well, please.
Judges, tomorrow too soon?
That is probably going to be too soon, yes.
You could do 3:30 on Monday, April 8th.
You have to do this, no, the prosecutor's office does.
Do we have anything else open that week? I hate to do it on a Monday because I never am certain that that's actually going to end at 3:30.
You have a jury trial the rest of that week. It looks like Wednesday. You have a prelim and a juvenile case at 2:30. I'm not sure how long that will last.
What is the jury trial?
The jury trial is Tory Marshall. You could do an 8 a.m. on Friday the 12th, and I can move the couple of sentencings.
No, let's do it on Monday then. We'll do it on Monday, May 8th. April 8th, I'm sorry. Monday, April 8th at 3:30. Mr. Mattson, do you want to be present in person for that hearing or do you want to do it by Zoom?
It doesn't matter. Judge, whichever is best for the courts, be fine with me.
All right, I think it will go more smoothly if you are here in person. So we will have you in person here from the jail.
All right, exactly what the hearing is going to be on that day.
So you've been charged with a violation of the terms of your probation.
Yeah.
For failing to report. So the hearing is going to be to determine whether or not you failed to report.
Okay, so it's going to be the trial that day.
Correct.
Okay, can I have the state police sergeant there at that trial?
What state police sergeant?
The state police sergeant of the arresting officers on the night of my arrest.
Who are the arresting officers?
I don't remember the exact names. But any state police sergeant in uniform would do.
Why do you want any state police sergeant to be present at the trial?
Just to show how arrests are made, and why they're made, and how they do the determination how they bring people into jail.
Well, how is any of that relevant to whether or not you violated the terms of probation?
I believe there's a lot of relevancy there. I don't see where any of it's going to affect the courts in any way, shape, or form.
All right, so the issue that the court is going to determine has nothing to do with things that happened during your arrest. The issue is whether or not.
No, it's not about the arrest. It's about the arrest for the violation of probation as well.
All right. The only issue before the court that day is going to be whether or not you reported. So your arrest doesn't have any relevancy to that. So I'm not going to.
I beg to differ, Your Honor. I beg to differ because the jury is going to be a jury of my peers, and at this time,
sir,
you're not going to have a jury of my peers.
Sir, there's not going to be any jury. You're not entitled to a jury trial on a hearing about violating your probation.
I'm sorry, I misunderstood. I'm pretty sure that last time I spoke to you, you said that I had the right to a jury trial for determining if I was guilty for a violation of probation.
I've never seen you on this violation of probation.
I've seen you, or I've seen you just the other day, last week.
No, you didn't. A different judge conducted that hearing.
You're Michael Olsaver, aren't you? There was
yes,
Sloan, and then there was you. I've seen both.
You did not see me last week.
I did,
and so you're not entitled to a jury trial on a probation violation. So, again, we will have you back in person on.
Well, hold up then. So, if I'm not entitled to a trial to determine if I'm guilty or not, this is a criminal court, isn't it?
It's a criminal court where you have already pled guilty to a felony and been placed on probation.
Because I was at risk of dying in this.
I've muted Mr. Matson's device because he continues to interrupt me and not let me finish what I'm saying. Mr. Matson, I was saying that this is a criminal court wherein you have pled guilty to possessing a controlled substance, and you were placed on probation. As a result of that, your sentence was to be placed on probation. Subsequent to being sentenced to probation, there was an allegation that you failed to report in accordance with the terms of your probation. That is an alleged violation of probation. There's no right to a jury trial for a violation of probation, so the court will conduct. Let
me speak to.
I've muted Mr. Matson again because he unmuted himself and interrupted me. We will have you back on April 8th at 3:30, Mr. Matson. This hearing is concluded. Yes. Mr. Matson, don't interrupt me, please. Mr. Matson, do not interrupt me, please.
I think the court is making a big mistake here.
Mr. Matson,
I've never signed anything to.
Mr. Matson, if you don't stop talking, I'm going to your device.
Well, I didn't want
Mr. Matson, stop
as my attorney. I'm a living flesh and blood man. They're trying to sentence in all caps names, and it's not me. I'm a living flesh and blood man. You're after a fictional person. The only one I've ever taken an oath to is God Almighty Himself. There's only one lawgiver, one creator, one judge. That's God Almighty. That's who I recognize.
And sir, you are Robert Joseph Matson, correct?
So, I'm a living flesh and blood man, attorney for a public officer or statutory citizen judge. I'm a living flesh and blood man.
All right. You are the living flesh and blood man who's known as Robert Matson, correct?
Attorney for Robert Joseph Matson, which would be the all caps name. Judge, there was something that I was trying to talk to my attorney about. Before you let me out of the hospital, I was in the hospital or the jail. I was experiencing a lot of pain and trouble. The jail was not treating me properly. After I got out of the jail, I went to the hospital, and they hurried and rushed me to Toledo Hospital, where I almost died. Had I not been released from jail when I did, I would be dead in that county jail.
All right, Mr. Matson, we're here for your sentencing hearing today. I'm not really able to address issues of medical treatment while at the jail.
Well, I was just saying that there was something I agreed to.
Mr. Matson, don't interrupt me, please. The medical treatment that people receive at the jail is not within my purview, and I'm not going to address that today. So,
Well, I just saying I was under duress when I
Mr.
talked to you.
Mattson, do not interrupt me, please. Have you had an opportunity to read and review your pre-sentence report?
I did with the secretary for Mr. Daly.
Have you had an opportunity to discuss your pre-sentence report with Mr. Daly?
I haven't had an opportunity to discuss it with him. I did with the secretary.
My secretary got a hold of
Mr.
him.
Daly, if you could just let me allow him to finish his answer. What were you saying, Mr. Mattson?
I did with the secretary. I talked to her over the phone and told her everything looked good. And I believe Mr. Daly was supposed to get back a hold of me. I don't know if he got too busy or something else happened.
All right. Thank you, Mr. Mattson. Mr. Daly, you wanted to say something on that issue.
Yes, my secretary contacted him in regards to the PSI. He said everything was right. He had no complaints about anything. I still tried to contact him back, didn't get an answer.
All right. So what we'll do is if Mr. Daly, if you'd be willing to step out into the hallway, we have an iPad out there that we can log into the Zoom session.
But I don't think he needs that. He's ready to be sentenced, Your Honor. You have any other questions, Mr. Mattson?
Yeah, Judge, I think the court is making a big mistake here. I've not.
I appreciate that, Mr. Mattson. And we've discussed it
before. Any of my rights or immunities. I'm not a statutory citizen. I am sovereign. I'm not somebody who's under the jurisdiction. I've never signed anything to
Mr. Mattson, if you don't stop talking, I'm going to mute your device. Okay? I've discussed all of these issues with you before.
Okay.
And
well, I object, but I mean, you're going to sentence me. That's what you're doing.
I've muted Mr. Mattson's device because he won't stop interrupting me. Mr. Mattson, what I'm trying to tell you is that we have discussed these issues before. You've raised those issues. I've ruled against those issues. And ultimately, you pled guilty of your own choice to the controlled substance possession of narcotic less than 25 grams. And so I'm going to sentence you on that charge today. If you'd like, I will have Mr. Daly step into the hall and you can have a breakout session with him so you can speak with him about your pre-sentence investigation report. If you have questions or things that you want to talk with him about regarding that report. So I'm going to unmute your device now and I want you to tell me whether you want a breakout session with Mr. Daly or not.
Hello?
Yes, we can hear you now. Do you want a breakout session with Mr. Daly?
Well, I've tried to talk to Mr. Daly before, I mean,
Mr.
about this.
Mattson, answer my question. Do you
Yes,
want
sir.
a breakout session with Mr. Daly or not?
Your Honor, you're going to do what you're going to do. I mean, I've tried to talk to the courts and reason with the courts. I mean, if you're going to sentence me today, then I just file for an appeal. I'm an objection to anything that happens today. I was under duress when I took the plea due to my life was at stake.
Mr. Mattson, please answer my question. Do you want a breakout session with Mr. Daly or not?
Mr. Daly hasn't been much of help for me, Your Honor. So I mean,
that is not an answer to my question, Mr. Mattson. Please answer the question. Do you want a breakout session with him or not?
Sorry, Your Honor. It just ain't been doing me any help, no justice at all. I mean, I've already said what I had to say. If the court is going to sentence me today, then that's what they're going to do. I don't agree with anything that's going on today. I'm sorry. It's just my life was at stake when I had talked to the courts.
All right, Mr. Mattson, please stop
Yes,
talking. So you refuse to answer my question about whether you want a breakout session with Mr. Daly or not. The law.
Well, I didn't want
Mr.
Mr.
Mattson,
Daly
stop
as my
talking.
attorney. Yes, sir.
The record, I placed Mr. Mattson on mute again because he's continually interrupting me. Mr. Mattson, what I'm trying to explain to you is that you have the right to discuss your pre-sentence report with your attorney before the sentencing. I've asked you 4, 5, maybe 6 times now whether you want to have the opportunity for that breakout session, and you won't give me a simple yes or no answer. So what I'm going to do right now is ask Mr. Daly to step into the hallway. We'll set up that iPad. I'm going to put you in a breakout session with Mr. Daly in order to make sure that I comply with with your rights to have that breakout session. So at this point, I'm going to set that up, whether you want it or not, so that we have complied with that requirement.
Judge, I just had a repeat of him from conversation earlier.
All right,
I mean,
Mr.
I-
Mattson, you're arguing the basis of your conviction. Again, you pled guilty to this charge. What I'm
And I
asking
tried-
you is whether, Mr.
tried-
Mattson,
Yes,
Mr.
sir.
Mattson, what I'm asking you is whether you'd wish to explain or challenge the accuracy or the relevancy of any of the information that is in your pre-sentence report. So is any of that information inaccurate?
Inaccurate as far as the person that reports they're trying to sentence in all caps names. And it's not me. I'm a living flesh and blood man. You're after a fictional person.
All right, so with respect to that argument, what the court will say is that I will leave the information that is in the pre-sentence report in the pre-sentence report and deny what seems to be some kind of a request to modify the pre-sentence report based on an argument that doesn't state any cognizable legal theory about a difference between Mr. Mattson as a human being and Mr. Mattson as something else. So the pre-sentence report will stand.
Well, Your Honor, you never even explained to me what the jurisdiction was. I tried from the beginning to
Mr.
see what the
Mattson, all
jurisdiction of
right.
the court is.
I'm going to mute Mr. Mattson again because he continues to interrupt me with a line of argument that I don't even know what to say about it. It just is, it's not a legal argument at all. It is some kind of fanciful belief that there's a difference between Mr. Mattson, the human being, and Mr. Mattson as some other entity, which is not recognized by the law, and I'm not going to entertain it any further. The probation officers calculated the minimum sentencing guidelines in this case to be from 0 to 9 months. Do you agree with that computation of guidelines?
I do, Your Honor. I do.
Thank you. Before the court passes sentence, Mr. Daly, is there anything you'd like to say on behalf of Mr. Mattson?
I've had the same conversations with Mr. Mattson the court's had. He's never wanted to talk about this case. He's always wanted to talk about what he perceived are constitutional issues. He pled guilty. He knew what he was doing. I do know that. I'm prepared to complete the sentencing now.
All right, Mr. Mattson, in a moment, I'm going to unmute your microphone and I'm going to give you an opportunity for allocution. That's an opportunity to say anything that you'd like to say on your own behalf before the court passes sentence.
Yes, sir. Can you
All
hear
right,
me?
is there anything you'd like to say on your own behalf?
You said that. I can say anything that I wish before sentencing.
You can.
I'm sorry, sir.
You can.
Okay. Yeah, yes, sir. Your Honor. I mean, before I took that plea, I told Mr. Daly that I wanted to sit there. I wanted him to sit there, get the cameras for the courts to prove that I was at the court date the day that I was put in jail, and said that that I wasn't in the court for a contempt of court. He said, and I told him I wanted to fight my case, but I had to be out because I had medical issues. Mr. Daly said that's fine and all, but if you stay here and you fight this case, they'll keep you in here for a year fighting your case. You will not be let out of jail. Your Honor, I couldn't do that. I was in major pain. I would have died in that jail. My proof is within the doctor's records in the hospital. I had a serious condition which would have left me dead within a week from the time that I took the plea. The following day after I got up, my wife was killed in a car accident. Because everything's been going downhill for me ever since. And now this with the courts. I don't feel that I've had a fair chance with the courts ever since I even started with the court, because the courts has not proven jurisdiction to me. I've not written any papers out agreeing in the contract saying that the courts can have any kind of jurisdiction over me. I have not relinquished any sovereign immunities that I have. I just don't feel that there's been anything fair, which is not going to be with the court system. I mean, I've tried to say I'm not a statutory person, who is within your jurisdiction. If anything, I'd be considered constitutional, but I'm not even under the constitutional laws, but I will use them if I feel necessary as a constitutional living flesh and blood man. There is no injured party. The only injured party would be the state's laws, which the state cannot be the prosecutor, the injured party, and the judge. Nothing's right. The court case either had been dismissed or moved to a higher court. And I wasn't going to sit there and be left in jail to fight my case for a year. I would have been dead. I'd have been stupid not to sit there and just agree with a plea that I didn't even agree with in the first place, just to save my life. I don't think that's fair at all. It's not right. There's nothing but wrong here. It's injustice, not justice. You can't be a constitutional person and a statutory person at the same time. Either you're one or the other. And Wi-Fi wasn't working properly on my computer. I couldn't draw up my own paperwork. I've been in nothing but severe pain. I've been able to move around and do much of anything for myself. The only one I've ever taken an oath to is God Almighty Himself. There's only one lawgiver, one creator, one judge. That's God Almighty. That's who I recognize. For me to sit there and agree to anything more than that would be me sitting there violating the laws of my God.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of your offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. As indicated, with respect to these sovereign citizen or whatever the other arguments you're making are, we've dealt with the jurisdiction issue in the past. I've ruled on that on at least one occasion, probably multiple occasions, and that ruling is not going to change. You will have appellate rights if you want to pursue those. You're welcome to do that, but you have pled guilty in this case. I think under normal circumstances that would be an adequate recommendation. With he's gone.
Oh, is Robert Mattson there, please? Okay, who am I speaking with? Okay. All right, thank you. This is Mike Stevenson, probation. Okay, he had sentencing this morning. He just left the sentence. Judge, I just spoke with a female at the number that he gave me, and she claims that he is at a heart doctor appointment at this time. That's what she claims.
Everyone back with us now. Mr. Mattson, we are in a court proceeding right now, and so I'm going to ask you not to eat anything and to remove your hood, please. All right, I'm going to ask you to remove your hood also, Mr. Mattson. Thank you. Mr. Mattson pled guilty to one count of controlled substance, attempted possession of cocaine, heroin, or another narcotic of less than 25 grams, pursuant to a plea agreement which dismissed one count of possession of cocaine, heroin, or another narcotic, dismissed one count of driving the license suspended, and one count of alcohol open container. So the agreement was to one count of attempted possession of a controlled substance, dismissal of the remaining charges, and that was apparently incorrect. There was no sentencing agreement in this case. This is Mr. Mattson's first felony conviction. He does have 4 prior misdemeanors. Those are all from 2015 or earlier. He has 2 2015 cases and a 2002 and a 2001. And so the recommendation in this case from the probation officer is for a period of 1 year probation. And I think that, well, it also, I should say, includes restrictions on alcoholic beverages and substance use, And I think that those provisions of terms of probation are appropriate given Mr. Mattson's Compass Needs Assessment scores. He did rate as highly probable in the categories of substance abuse, family criminality, residential instability, and social environment. He does have a substance abuse history of cocaine, fentanyl, painkillers since 2005. I think that it is appropriate to try to get Mr. Mattson some help for his substance abuse problems. The concern I have in this case is that is whether or not Mr. Mattson is going to be willing to comply with the terms of his probation. He has, in numerous court hearings in this case, made a number of what he believes are constitutional and jurisdictional arguments that have absolutely no legal merit whatsoever. And he continued to challenge the court's jurisdiction here this morning. I understand that that may be an honest belief that Mr. Mattson has, and I don't know where it comes from, but I will say Mr. Mattson would be far better off taking legal advice from Mr. Daly than from wherever it is that you're getting it to make you believe these arguments, because as I've ruled repeatedly, there's just no merit to them. They're not rational or coherent arguments under the law. And the concern that that raises with me is that Mr. Mattson, if he does not believe this court has jurisdiction, why then would he follow the terms of his probation? And so if that's the question, then the question I have to ask myself is why would I put him on probation if there doesn't seem to be any indication that he would follow the terms of the probation? The other side of that coin is that I think a lot of this stems from Mr. Mattson's substance abuse issues, and the better way to get him help for his substance abuse issues is to put him on probation and get him into some kind of services to help him deal with that. So ultimately, Mr. Mattson, I'm going to give you a chance at probation. I hope that you are willing to comply with the requirements that are outlined in terms of your probation, which I'll read to you word for word in a moment so that you're aware of them. If you choose not to comply for the reasons you've stated or any other reasons, you can rest assured you're going to find yourself in violation of the terms of your probation. And then I am going to be imposing other penalties, meaning for you jail time. And I'll just tell you now, it'll be a short leash, because if we continue down this road, I'm already suspect of your ability to comply. So any violations are just going to confirm that for me, and you're going to find that I'm going to lose my willingness to give you a chance. So it will be the sentence of the court that you serve a period of probation for 1 year, that you serve 29 days in the Lenawee County Jail with credit for 29 days served. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. And you must present proper identification at the time of testing. You must pay the cost of your substance abuse testing. You must not be in possession. You must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician. And you must not be with anyone that you know to possess those items. You must complete an outpatient or residential substance abuse treatment when you are referred by the field agent. You must complete a substance abuse assessment when you are referred by the field agent. You must pay a $30 per month supervision fee, so long as there's no electronic monitoring. If electronic monitoring becomes necessary, that fee increases to $60 per month. You must also pay court costs of $750, an attorney fee of $450, a crime victims' rights fee of $130, and $68 state costs. And that, Mr. Mattson?
Yes, I do. Hey, Judge, I just had a couple questions, if I may, from you concerning what you just said.
All right. What's your question?
Well, if there's a crime victims fee, I'd like to know where the victim is, and also, Your Honor, you said something about the jurisdiction. If there's no problem with the jurisdiction, I mean, how come you couldn't tell me exactly which jurisdiction you're operating under? Because I would have to object to what you said. I mean, it don't make no sense to me, Your Honor.
I told you that before, Mr. Mattson. I'll tell you again. I'm operating under the jurisdiction of the Michigan Constitution that sets forth the fact that the state has various circuit courts. I'm the judge of one of those circuit courts, that one being where you are alleged to have committed this crime and where you pled guilty to this crime. As far as the crime victims' rights fee, that is assessed in every case where there is a guilty plea or verdict. That is done pursuant to statute that was enacted by the Michigan legislature, and it is required to be imposed here. So that is why I did it.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hello, how's it going?
Could be better.
All right, so my understanding, you want to represent yourself? All right, you're more than welcome to represent yourself, but here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial, and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules, so let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I'm the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me. There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
So we're back on the record in 2024 CR 2974, State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for.
That's right.
So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness, you need surgery, and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right. Norma, get someone from manage to sign counsel here, please. All right. Just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right, so let the record of the court show that I, Hector Casanova
Just one
Jr.
second.
The accused
Just
in
one
the
stop.
Yes, sir.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action. Furthermore,
let me
let the
stop
record
you.
also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment, and the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from managed assigned counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mhm.
I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mhm.
Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under.
All right, I'm
admiralty or
gonna
military
counsel,
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm gonna stop you right there. What is gonna end up happening, I want you to hear me clearly. An attorney is coming over for managed assigned counsel, period. That's it. So have a seat, managed assigned counsel will come over. Do you understand? Yes or no?
I do not understand.
All right, do you understand what it means to take a seat?
I do understand.
All right, so take a seat.
Yes, ma'am.
Thank you.
Of course.
We have talked.
Mhm.
I've informed him that I'm here, to help him in whatever he needs help with.
Mhm.
He's gonna consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay, all right, and so you'll be appointed as standby
Yes.
counsel then?
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing, so.
All right, we're gonna go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes. All right, so Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
Yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right, who threatened or coerced you to come to court?
The county of Bear, Texas.
How
State.
so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date and you can accept the state's offer, come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date and then you'll sign it. Mr. Bonk will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome. And thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
Mr. Bout, it's your appearance for Mr. Schomer.
Your Honor, for the records, Jeff, about very out. With Mr. Stover, sir, you tell the judge your name for the record, please.
Kenneth Shaw.
Thank you. Hold on just a minute. Just so you know, we told Mr. Smith, we'll just give him a notice.
Yeah, thank you.
We'll let you know what the date is.
I think I
Okay.
got it right up right here from Mr. Smith.
Yeah.
I don't know why there's two.
Oh, no. It's just an adjournment.
Yeah, adjourn for discovery.
Gonna be in person, just so you know, remember, you did a sentencing, Mr. Louder would change to,
Yeah, Delauder's not a pretrial day.
That's fine.
Yeah, so this will be a different date.
Absolutely.
Okay, all right.
Your Honor, today's the date it's absent for violation of probation.
I've got two files. I've got a file ending in 1182, and I've got file ending in 1648.
Your Honor,
And-
I think violation of probation is he picked up new charges. I'm not addressing the new charges because he has a retained attorney
Right,
on the new charges.
and a date to come back on that file.
Right.
Right.
But he has an issue today, Your Honor.
So that's not the only issue today. The new charges are an allegation that they would be a violation of probation, but my indication from the probation department is that Mr. Schomer has not done anything I've told him to do. Told him to do treatment at GrowthWorks, told him to do community service, gave him work program days. Has he ever showed you any indication of treatment?
no indication or documentation of treatment, Your Honor. He did complete his 30 hours of community service, which was a sanction for appearing at the court intoxicated
Right,
and no documentation of treatment. He did complete the order and have 10 days on the work program. Again, that's a sanction. Completed 8 or 9, I believe, and on that 8 or 9th day was when he was intoxicated while on work.
right. So he hasn't finished the work program. He showed up here, including today, at least 3 times under the influence. What was his PBT today?
Today is 0.10.
All right. Do you have, Mr. Bowditch, do you have any concerns whether or not Mr. Schomer is so intoxicated that he can't make informed decisions today?
Your Honor.
All right. So are we entering a responsible or a guilty plea to the violation or a not guilty plea?
Well, Your Honor, I said he's plead guilty. He picked up a new charge and he's intoxicated in court. That's obviously a violation. So we be pleading guilty. He said his explanation, he can afford that to Your Honor.
I'm willing to listen to anything you've got to tell me, Mr. Schomer.
Excuse.
It was last night, I had girls and friends come over, we were playing cards till like 2 o'clock in the morning. And I went to bed after that, I didn't wake up this morning to sign anything, right? I came here, took a shower, had my coffee, and I showed up here early.
All right.
To tend to, a case, that they think I was drunk, and there's no proven evidence of that.
I'm not talking about that file. That's,
Okay.
you've got to,
I was here this morning.
yeah. Yeah, but you knew you were coming here. It wasn't a surprise visit.
Yeah, I didn't come in here intoxicated.
You're legally intoxicated by law, sir, don't argue. By law, you're legally intoxicated. The state of Michigan says at a 0.08, you are presumed to be intoxicated.
Come in here. I had a night, okay, with friends, okay, we enjoyed our moment, okay. I had a few drinks, okay, I can't.
Sir, don't blow smoke up my ass. Listen to me. If you're at a 0.08 at 11 o'clock in the morning, you had more than a few drinks last night. And you had more than a few.
Say, who was counting? I mean, I'm just enjoying the moment.
I bet you'll be counting now because I'm violating on both these files and you're going to do 90 days in jail on each file. I don't understand how your head works.
Listen, I can get Uber to take.
No, I'll provide transportation for the next trip. 90 days in jail on each of these 2 files, and then we'll close them out unsuccessfully.
my home.
That's not my concern.
It's my job.
That's not my concern. Sir, I have given you every leeway.
I didn't do this intentionally.
You accidentally got so drunk last night that you're at a .10 at 11 a.m.
I felt,
Then grow the hell up. You're not 20 years old. The kind of behavior I'm seeing from you is what I'm used to seeing in 20-year-olds. Go to jail. Goodbye. We're done.
What do you want this way? Are they here now?
no.
Okay, we got.
Never ceases to be baffled. You know?
I'm not threatening you. Say one more word and that's 30 days. 30 days.